Thank you for joining this session this morning. So my name is Joe Carson, and I'm an engineer who works for the Department of Energy, and I've got a number, my job has been doing oversight of contractors as they're operating, or in my case more demolishing, shutting down and decommissioning DOE facilities, particularly nuclear facilities. So I'd like to get an idea of what agencies, federal agencies that you may interface with, or do you think that people interested in energy and the environment may interface with? Any?
TVA.
TVA?
Absolutely.
Yep, it's a government corporation, but it's a federal agency. Others? For nuclear, NRC, EPA?
TDEC.
Well, TDEC's a state.
Oh, yeah.
Department of Energy? OSHA, it was in the Department of Labor. You have mining, would be Department of Interior. Oil, they're the ones that license oil rigs, like the Deepwater Horizon. That oil spill was Department of Interior had licensed it. Any idea how many federal agencies there are? I'll say, put up your hand, less than 100? 100 to 200? 500?
I'll go
Actually,
for that.
there are about 300 federal agencies. So let me, that's a little bit of my background. And I've been through the mill because I've been a whistleblower, and I've actually have prevailed. So I want to make clear, as I'm being taped here, I'm speaking as, I'm employed by DOE, but I'm representing myself. I'm not representing DOE and stating being here today. And as part of this presentation, I'll be making what a term of art, protected disclosures. And by law, federal employees are supposed to be able to make protected disclosures without experiencing reprisal. But that law is more observed in the breach than in actuality. And that has a lot of explanatory powers for what's gone wrong in the federal civil service, federal agencies, and then to America in the particularly last 35 years. So let's start with we have an hour. I'd like to get some interaction because I have a pretty singular story. I have probably prevailed in more whistleblower reprisal litigation than any other federal employee in the history of the civil service. So I've been through the mill. I'm still employed. I'm still married. Still have a security clearance. So I'm unusual. So federal employment. Going back, and these are for the lawyers who may be here. There's not all that much law that's relevant to what I'm going to be speaking to today. Some acronyms. I'm afraid I'm a Fed for too many years. I speak in acronyms too much. I will try not to. I've just shared a little bit about my background. So I didn't start life as a Fed. I was in the Navy, but I was in this private sector for a number of years before going to work for DOE. So as I identify myself more as a member of the engineering profession who now works for the Department of Energy. So if you're an attorney or law, I think you kind of would resonate to that. You're going to be a member of the legal profession. You're going to have your employer, your clients, whatever, but you're going to be a member of that profession is what you're going to be doing for your vocation. So I'm a member of the engineering profession. PE stands for professional engineer. I'm licensed by the state just as an attorney or a doctor or an architect is. But relatively few engineers are licensed, and we can get into that, but it's not all that. It's germane, but not that germane to the bigger picture of what's wrong with the federal civil service. But relevant to my situation as a whistleblower, I'm in the subset of whistleblowers that would be also considered a mandated reporter. In that, as a professional engineer, I have a positive duty to blow whistles when necessary to protect public health and safety related to my professional duties, regardless of possible workplace retribution. And that's one reason I'm still employed, is I can play that I'm just doing my job as a PE. Okay, so let's go to our federal civil service. Andrew Jackson, from Tennessee, when he gets elected in 1828, he had lost a contested election in 1824. It was kind of bitter, but his The reaction was, well, to the victor belongs the spoils. So everyone who was a federal employee was basically, you're out of a job, and now the people who supported me becoming president, you now have a job. So it was patronage, it was a spoils system. And it was existed before Jackson, but Jackson really was the one who really churned all the tax collector jobs, all the postmaster jobs, and not that there wasn't a federal civil service then, but there weren't that many civilian federal jobs then as compared to now, but he made the patronage. And that was a system that continued until 1883. And what happened in 1883, or preceding it, was 1881, President James Garfield was assassinated by a disappointed office seeker. He dies a horrible death. He started, when he lingered through the summer, when he was shot, he weighed over 200 pounds. When he died, he weighed close to 100 pounds. And presidents, you were hounded. People were, you couldn't walk down the street without people saying the term lobbyist. They were people who wanted a job. And so you would walk out, you'd have all these people there trying to give me a job here, there. This is this is why I've got my political support. At any rate, so everybody saw the movie Lincoln a few months ago. So Congressman Pendleton was one of the big players in getting the laws, the 14th Amendment passed. Well, he played a role. The Pendleton Act of 1883 created what is now the Federal Civil Service, where jobs would not be based on patronage, but there would be a career federal civil service. So as the administrations changed, the career people would not, senior people would change, but the career people would not change. Okay, the biggest single change in the Federal Civil Service between 1883 and 2013 is the Civil Service Reform Act of 1978. And that's a post-Watergate reform, because Nixon abused the Federal Civil Service and the agencies. He was there to use power to keep power, reward your friends, punish your enemies by having the IRS, sick him with the IRS. But he was trying to, even much more so than his predecessors, politicize the agencies. Also, the Civil Service Reform Act, in part, is a response to the Church Committee about the abuses at CIA and FBI in the 60s and 70s and 50s. All right, the primary objective of this is our government, all right? I'm giving you kind of a civics lesson, but if our government's not working right, I'm trying to share it's not working right. This is a piece of it, and I think an important piece of it. So what's the objective of the Civil Service Reform Act? Is so people like me can do our jobs to serve people like you, through these agencies in a trustworthy manner, ethical, competent, accountable, and these are things that are codified in law here, have you got it, the definitions of merit system principles and prohibited personal practice? I think I passed it out, okay? These are terms that were created in the Civil Service Reform Act, merit system principles, and which is basically a federal employee should be hired because of merit, as opposed to because of sex, because of family ties, because of political party ties, because of some other reason, because they bribed the bribing official or the hiring official. You're supposed to be hired on merit, you're supposed to be promoted based upon merit, you're supposed to be demoted or fired based upon lack of merit, as opposed to other non-merit factors such as sharing, family ties or political persuasion or other things. Okay, one of the merit principles that's more relevant to my situation is federal employees are supposed to be able to make protected disclosures without experiencing reprisal. The term protected disclosure means, if I were to go to work and curse my boss, I could be fired for that. That's not a protected disclosure. But if I go to my boss and I voice reasonable concerns about violation of law, rule, regulation, then I should not be fired for that. So the protected disclosure is kind of a term of legal art, but it's relevant to people like me being able to serve people like you. Okay, so prohibited personal practice, another term of art, but essentially a prohibited personal practice is when an agency violates a merit system principle, i.e., the hiring official hires his lover as opposed to the most qualified person. Well, then that promotion is a personnel action. It wasn't based upon merit, so therefore it's a prohibited personal practice, because you're not supposed to, in hiring and in promoting, not exhibit personal favoritism. Okay, this is real life, 2012, the biggest survey of federal employment in history. Take a guess as to how many people currently, right now, think promotions in their work unit are based upon merit. 10%? 20? 50? Come on. Come on. Give me something, right?
25,
What?
30s.
A third, 1/3. As of right, and that's government-wide, so that, and when they did this OPM survey, that you can drill down into offices and agencies, but government-wide, it's out on the website, government-wide is about a third. So about, now that sounds a little worse than it is, because a third of people say promotions are based upon merit, about a third say they have no opinion, and about a third say that they're not, okay? But only about a third right now think promotions are based on merit. So we have a perception, at least, that promotions are not being based on merit. Well, that means prohibited personal practices are more rampant in the federal civil service, okay? Now, I'm sharing with you, from being a federal employee for over 20 years, too often, the wrong people get promoted for the wrong reasons, okay? And that's also very deleterious to the integrity of the federal civil service when people want to get promoted. They want to provide for their families. They don't want to have to then, because promotions are from within. So you think you're more qualified than your counterpart or whatever, and if you think your counterpart is being promoted because he kissed up, or because he has dirt on the boss, or because, more readily, the boss has dirt on him or her, so therefore that person couldn't expose rock boats with that boss, you'd make a little empire, okay? And that, so how many people have a real great trust for all these federal agencies and federal civil service? The answer is not much, right? Not enough. Not enough for all the issues that we're trying to deal with collectively with the environment. Like I'll say a carbon tax. One of the things that's kind of that would have to happen for a carbon tax to pass is the rank and file citizenry would have to believe it's trustworthy. It just won't be a big game that's going to be scammed. Okay, so if we don't trust our instruments of government, then it precludes us from doing things collectively that we might have to, that we could do, should do to protect the environment. Okay. Who do you think benefits from a federal civil service that's discredited, or is weak, or is more corruptible because it doesn't work for merit system principles? We just had, Occupy, Wall Street, the corporates, okay, the 1%. How many countries in the world? Not 1,000, but like the UN, how many? About 200? Okay, how many of those countries are basically kleptocracies where the rich get rich and the poor stay poor? Okay, so in that kind of a case, do you think those 1% want a trustworthy, independent civil service agencies that could, kind of keep a level playing field for everyone? No. They want to corrupt them. They want to be able to use them to enrich themselves. More so, they want the rank and file citizenry to hate and distrust the government, so they won't even think that this government could be a tool for the common good. And that's what I see happening more and more in America. Okay? And I'm basically finding a pretty lonely post in my, my sphere, saying, no, I'm supposed to be able to do my job, ethically and competently without being slapped around. And one reason I'm fighting this so hard is I would have quit right now. I'm the wrong message to most federal employees. Most federal employees, even though I'm still hired, they would say, I would never do that. I will look the other way, seeing the mud you've been having to drug through. And I can't blame them. Okay, that's the answer to my story right now, and that's very relevant, to TVA. I think. Okay, anything? Pushback? Okay, all right. But this is, so if you now know more than most feds. If you say the most feds mess with the principles, say, what? Prohibited personal practices. They may know it, but they don't really get down to that kind of detail of what they are. Okay, so now we're going to get a little more. This is the most important concept. You can wrap your head around this. You will understand a lot that you haven't understood up till now when you're dealing with federal agencies, or why they don't work, or how they work the way that they do. Most federal agencies I'm talking about, they tend to be regulators. NRC regulates commercial nuclear power. EPA has a lot of rules with regulating different of our activities. Department of Interior, these mining offices, they have regulating power. OSHA regulating power. So, well, let me, I could tip my stop here. No federal agency regulates its management culture. And that's because Congress didn't trust them to. And it's also because Congress wanted to make a comprehensive system for 300 federal agencies. So, Congress created, these two reasons. So Congress in the Civil Service Reform Act created two tiny, obscure agencies you've probably never heard of. which play essential roles in the regulation of the management culture in every of these 300 federal agencies. And if you can understand that, then you can understand what I'm saying is so important, because if these two agencies aren't doing their thing right, it impacts left to right, top to bottom, front to back, everywhere, okay? And that's why when you hear about the IRS scandals about conferences, or going after the Tea Party, or throw a dart, the Deepwater Horizon, or any of these agencies, everyone makes this assumption the problem is within this agency, which is good, but not enough, because these other two agencies, if they're not doing their thing, then the NRC, the other agency, there can be causes outside that agency that are manifesting in corruption and dysfunction in that agency. So like if we have a body, we all have an immune system, right? What if our immune system isn't working right? We're going to have all kinds of different medical issues, but if the doctor is just treating the issue without going after it's the immune system that's making you more susceptible to all these other things, you're going to be in the doctor forever. But if you can tune up, if you can correct the issues with the immune system, then you won't have the other issues. So Congress created these two tiny agencies, the Office of Special Counsel, Merit System Protection Board. They are the immune system for the federal civil service. If they don't work right, it's going to be sick forever. And that's what I'm claiming. They're not working right. They have never worked right in 35 years. So if I'm correct, in a sense, it's good news for America, because we face a lot of issues that everybody here knows. And if there's an unexposed, let me see, a previously up to now contributor to a lot of the causes, and it's readily correctable, that's kind of good news. It's kind of like saying my business is going broke, I'm going to have to move out of my ... and you find out there's been an embezzler. Well, it's bad news there's been an embezzler, but it's good news you found it out, and maybe your business model's not so inherently wrong, it's just you had something that was going wrong you weren't aware of, okay? Or if you're in the Army, and you keep losing battles, you might think we don't have enough heart, the other general's smarter, we don't have the right weapons. No, there was a spy. You get rid of the spy, it changes, maybe that could explain why we were having all the, in part. So my point is, if I'm correct, if the Office of Special Counsel, Merit System Protection Board are not doing their duties, that is good news, because it's fixable, and it could explain a lot that's gone wrong, i.e. things aren't as bad as they might otherwise seem. Okay, can I have an amen to that?
Amen.
Okay, thank you. Because that's really why I keep whacking away at this stuff, yes.
So what House or Senate committee would you speak to about the issue?
Well, I've spoken to them many times, but on the House, it's the committees with oversight of the Federal Civil Service. In the House is the Oversight and Government Reform Committee, and in the Senate it's the Homeland Security and Governmental Affairs Committee. And Congressman Duncan is on Office of Oversight and Government Reform in the House. Yes, sir.
So in the case of the Nuclear Regulatory Commission, after 3 Mile Island and Chernobyl, they got religion, so to speak, about nuclear safety. And they really were going after issues that had been identified about nuclear power plants that were not safe. And the nuclear industry started complaining a lot to their Congress people. And the Congress people, I've seen the hearing, or I've seen transcripts of the hearing in Congress, where the congressional committee, I don't remember which one, I don't remember the year, but they basically said, if you don't back off to the NRC, we're going to cut your funding, and you're not going to see the light of day. And after that point, the NRC became a lapdog and not a watchdog, and it's very much a lapdog to this day. But I think that that's a big factor too, in that these regulatory agencies, the political environment, the politicians don't let them do their jobs. Whether it's the governor for the state of Tennessee, and TDEC or NRC in this case. So I don't question your points here,
right,
so much as add to the equation that there's more wrong, that there's other aspects.
Yeah, you raise a good point. I am not saying this is a panacea, but it's a piece that's wrong.
Right.
That's readily fixable. But to pick up on what you're sharing, so you're the NRC safety engineer, okay? And you're writing a lot of concerns, and you know what? They're just going into the round file. Well, what do? because I was in DA, that was my scenario. What do I do? And what I'm sharing with you, because NRC is not self-regulating for its management culture, who has the back of that NRC inspector? It's not someone within the NRC, it's the Office of Special Counsel. And if the Office of Special Counsel is not there, that means that the NRC person has no one to cover his back, which means, you know, I gotta take care of my family. I don't want anyone to get hurt, but I gotta take care of my family. How many times I've heard that? That, you know, people are not walking around in the Federal Civil Service with horns on their heads thinking, how am I gonna, all right? They face very dismal realities if they're concerned. And I'm saying, I'm on camera, right? All right? I'm pointing my finger now at Obama 20 years later. Because what is one result of having this system that Congress created with, you know, an engineer, three-legged stool, all right? So to regulate the management culture in any agency is essentially a three-legged stool, where the agency head, I'm using these acronyms again, is responsible to prevent prohibited personal practices. And I've got a list of prohibited personal practices and merits and principles. The Office of Special Counsel, it's like a police force. And it's unique in the history of our government, and I think any government. It is a federal agency created to protect federal employees from federal agency law breaking. I mean, can you kind of wrap your head around that? I mean, you know, so there's no real analog to it, which is one reason when it's not working, you can't compare it to something else, okay? And the Merit System Protection Board, it has, one of its roles is to conduct special studies, that's the term in the law, of the Office of Special Counsel and agencies to determine whether, when things go wrong, if that was a result in part from prohibited personal practices, okay? So, all right, let me make some dramatic you know, black and white statements of law that could be falsifiable, right? I'm claiming, contrary to law, federal employees as a rule cannot effectively voice concerns. That NRC employee whose boss is running into the garbage can, he has no effective recourse. I'm not going to say 100% of the time he can't do anything, you know, but as a rule, and that's contrary to law, because as a rule, he's supposed to have effective ways to voice concerns. Effective being, it gets a timely and objective resolution. Not there, okay? Contrary to law, federal employees are not adequately protected from prohibited personal practices. You are very readily subject to reprisal. Promotions do not, you know, as a rule, always promote the most meritorious person. Only a third of feds right now think it does, okay? And there were other, and that's also very deleterious to the integrity of the federal civil service. Yes?
I just wanted to make a comment about what you're saying. In the federal system, the way management is chosen, the senior executive service, people are going to choose people that are like themselves. There are also political appointees who are put in at every administration.
Right.
But when you've got the same kind of culture for management all the time, and that never changes because people are choosing people like themselves, you foster a culture that allows the prohibited personnel practices.
Mm-hmm.
That's one, I think that's another part of all
right.
this.
The wrong people get promoted for the wrong reasons, prohibited personal practices, which then allows reprisal more readily to take place. Because the federal workplace, this is kind of like common sense. You know, a federal workplace that allows any kind of prohibited personal practice is more likely going to allow every kind of prohibited personal practice and other kinds of wrongdoing, law breaking too. So the prohibited personal practice is supposed to be kind of like, that's, if you're allowing, that's kind of, you know, if you, there was back in the 70s or 60s in New York City, and you can tell I'm not from East Tennessee, but they tried to stop people breaking windows in abandoned homes. And the thought being, if we can stop people from breaking windows, then we probably won't have all the thievery, assaults, everything else, right? So it's supposed to be like the tripwires. Prevent prohibited personal practices. Because these merit system principles, they are the bedrock values of the management culture of the federal civil service. And if they're being violated, it's like walking around, you know? It's just all window dressing, you know? I got to take care of my family. I want to do the right thing, but I got to do that, you know, conditioned by I got to take care of my family. Okay, so like 9/11, we do all these reviews. Did anybody in Congress ask the question? Well, could Could one causal factor be that people in FBI, CIA, all the FAA couldn't effectively voice concerns? Or were not adequately protected from reprisal? No, those questions don't get asked. We don't ask those more transcendent questions. We created a three-legged stool, but then when something goes wrong, we only look at the inside that agency without looking at the bigger picture of the management culture. And agencies simply don't regulate their management culture, self-regulate. So this has gone on and on and on. So the Office of Special Counsel was supposed to be very transparent. So if you're going to stick your neck out, you got some reason to believe you're not going to get your head chopped off. But it behaves as a black box. It's unauditable. Okay. The Americans Protection Board is supposed to be doing special studies. Hasn't done one in 35 years. None of the Office of Special Counsel. Why not? It knows what we're to find. So doesn't want to do it. So what does that mean? That means why I'm here talking to you. So the president, I mentioned this three-legged stool. Well, by law, the president has the duty to take any action necessary to ensure the federal civil service embodies the merits of the principles. Well, if he's not getting feedback from the Americans Protection Board or Office of Special Counsel that PPPs are pretty rife, what does he know? You're the agency head. And I've had conversations with people close to the agency head in DOE. He'll say, well, I'm tasked to prevent prohibited personal practices. And you know what? I've issued policy and I've given training. And I say, good, but is it effective? Who knows? But no one's telling me it's not. Well, the people that would be telling you it's not would be the Office of Special Counsel, Americans Protection Board. And they're not. They're not doing their thing. So we're all like steaming into the dark, like the Titanic. There's an iceberg out there, but no one's, the radar's turned off, or the helm's not connected to the rudder. So we have this broken immune system of the Federal Civil Service, and when all these things go wrong, we just focus on that given agency without looking outside the agency to see the bigger picture. So it's the president's job, and that's why, Mr. Obama, you are failing or refusing to do your duty. And one reason I can say that, because he knows I'm right. And he doesn't want to give me a chance to make my case. That's what I perceive. I mean, why am I still employed with a Q clearance? I go to work every day. People pat me on the back. I'm right. And we don't want to say that we've been wrong for 35 years. Because I've been to the Supreme Court twice. Okay. No one has said I'm wrong. They've always found other reasons to get my case dismissed. But this is a lot of explanatory power for why people don't trust the government, and because the government doesn't merit their trust, and why in collecting these collective issues that we face, we're kind of like up a creek or we're in a canoe with no paddle. If we don't trust the government, then a lot of things we have to do to get things done, we don't trust it to get done. Well, that benefits the 1% who don't want to have their prerogatives controlled by a federal civil service or federal agencies. Okay, so 2 million federal employees. All right, how many people do you think this Office of Special Counsel has to police this workforce? 110. You think of Barney Fife with a single bullet, right? So why do they not do their job? They don't have the reason. Going back to what you were sharing, they can't. They have to cut every which corner they possibly can just to get through the day. Okay? And the Americans Protection Board, it basically renounced its duty to do special studies of OSC. So it does special studies, and I'm Christian, right? So I'm going to use the analogy to the Garden of Eden with Adam and Eve, all right? So God makes Adam and Eve. He says, you can eat anything in the fruit of any tree except one, okay? Well, Congress creates MSPB, and it tasks you to do special studies. And it says to MSPB, you can do a wide range of special studies, but ensure you study whether federal employees are adequately protected from prohibited personal practices. And guess it's the one thing it hasn't studied. Because, and it kind of says, well, it'd be kind of a conflict of interest, we'd be reporting on ourselves. Well, why don't you tell this to Congress? It's all under the table. Okay? So if you were to ask the chairman and I have asked, Mr. Chairman, 9/11, or going to war in Iraq for false pretenses, or the economic meltdown, or the failure of the levees, or space shuttles falling out of the sky, or the VA scandals, or any of that stuff. Do any of them evidence that the public interest in a civil service is not adequately protected from prohibited personal practices? Guess what her answer is, please. Please.
Didn't answer.
I've asked and she gave an answer. Her answer is, I have no opinion. But Joe, if you read all these special studies, you can come to a more informed opinion on your own. Well, the law tells her to make an opinion and to tell it, report it to the President and Congress. And she won't. Yes.
In any of the surveys that the federal agencies have done about employee satisfaction and what's going on, do they ever ask them about the Merit System Protection Board or the Office of Special Counsel, or whether they feel like they're protected?
Very good question. There's the agency that does these surveys is called the Office of Personnel Management. And by law, the Office of Personnel Management cannot ask about the functions of MSPB and OSC when it does its surveys. It relies upon MSPB to do the special studies. And, Congress created this kind of complex system.
What's the law that keeps them from doing that?
I could give you the site, but it's in the law that governs OPM. What it does some, OPM will do oversight of whether promotion, whether the announcement, the vacancy announcement made properly, this and that. But when you cross into prohibited personal practices, it's told you can't do oversight of that because that's OSC and MSPB's bailiwick. And that's in the law. So if MSPB doesn't do the special studies, these special studies are supposed to answer those questions. But MSPB just will not study those topics. And I'm not making this up. Ask the chair of the MSPB. That will be her answer. I have no opinion. And I have no intention of doing special studies to where I'll have an opinion. So that means, the Office of Special Counsel, this is like again, it's kind of I'm an engineer, so it's an intricate model. So the Office of Special Counsel is kind of like a prosecutor in a sense in this federal civil service. So if the Office of Special Counsel were coming up with a lot of findings of reprisal, it cannot direct the agency to fix it for Carson, or fix it for Jane, or fix it for Tom, okay? But what it can do is initiate a legal action, if you will, an administrative action in front of MSPB, and then if MSPB agrees with OSC, then MSPB can order the agency to do something, all right? So the MSPB's got kind of an adjudicative function too. So if OSC were too zealous as a prosecutor, who was bringing forward cases of prohibited personal practices that didn't really have merit, MSPB could check it via the adjudicative function, okay? But MSPB is also supposed to be a balance on OSC via the special studies to see if OSC is just throwing all the complaints into the garbage can. It's the special studies function supposed to say, OSC, you're underperforming your statutory duties. But it doesn't do that piece. So OSC just doesn't have to do anything. So if my point, you found the kind of chain, so you're the NRC inspector who gets his safety findings, her safety findings thrown into the garbage can, you go to OSC with or you rock boats about it, you allege reprisal, OSC throws your complaint to the garbage can, it's futile. It's futile. And the president will say, what do I know? The head of the NRC will say, well, OSC and MSPB haven't told me there's any problem, so there's the policy against prohibited personal practices, and I've trained it's like, we have a problem with theft in a dormitory, and if you go to URA, you go to UT, well, we've issued policy, we've given training, what's your problem? Well, the problem is, we still haven't got a theft, right? We don't have an enforcement mechanism, we just have empty words. And that's what we have. Yes?
Just a quick question. Have you worked with APIEL?
Yes. And GAP and POGO. And this might sound caustic, but I've been with them too many years. They are good watchdogs until the government law breaking benefits their business models, then no. And if OSC worked as intended, they would be less necessary. So they just don't want to go there. Now, I'm an engineer who is sharing up being a mandated reporter. Okay, people here are attorneys, going to be attorneys. What happens when if your employer is a government agency or your client? You know what? You're a mandated non-reporter. Because if you're employed by a government agency and you're an attorney, your employing agency becomes your client, whose duty, whose interest you must hold paramount. So I talked to the attorneys at OSC. OSC is about 60% attorneys, and they tell me, Joe, we don't disagree with what you're saying. These are good questions, but 35 years ago, we were told to interpret the law this way, when the Civil Service Reform Act was passed. And because OSC is our client, we really can't support getting these laws interpreted, because what if we're found wrong? You know? So it's, and I want to be, a little more balanced with it, because again, the people at OSC, I'm not going to say they have horns on their heads either. But I've shared that OSC, there's no analog to it, so legal ethics just don't really fit. Current legal ethics, the scenario of I'm an attorney at OSC who's supposed to protect people like me. I don't think I'm interpreting the law right, but this is how my boss is telling me to interpret the law. And you know what? I don't have an OSC. I work for OSC. Oh. Yes. You had your hand up?
So maybe there could be a petition to our lawmakers to investigate the OSC?
Yes, please. I've been trying, but that's when Peer, Gap, and Pogo say, no, we don't want to do that because, for whatever reasons, It's not in our economic interest what the real reason is. They make money. There are relatively few foundations that give most of their funding. So the business model of a peer, some of these so-called whistleblower advocacy groups, they need people like me to go to them with my insider knowledge, because I don't trust the system, so I kind of do this back channel thing. Well, they take that insider information and they kind of pre-masticate it. I mean, I'm saying I'm being facetious, but they will kind of process it. And then they can trade it for access and influence with the media in Congress. Okay? Which, and then if you're in the media, why don't you listen to Joe Carson? Well, if I listen to Peer, I'm going to get a good story every week. You only have one story. The Peer is kind of in cahoots with this law break. So I mean, it's a very, it's inside the beltway, little back scratching, symbiotic relationship. And then if you try to get Congress's attention, you know how you have to get Congress' attention? You got to get media attention, because Congress follows the media. They're reactive. And you go to the media and you say, I'll write a story if I get someone from Peer, Gap, or Pogo to agree with you. It's just, and I kind of see that. I see this kind of heading off a cliff. And I'm saying, like, I got to keep waving my hand. I mean, I'm either, if I'm the boy crying wolf, prove there's no wolf there, discredit me, or no, just more ignore. Pay my salary, ignore me. Yes.
So what kind of national media have you done?
Well, I've gone to the Washington Post numerous times, New York Times, things that cover the agencies quite a bit, or federal employment, and they always refer me to, because this is kind of in-depth detail, and they say, I can't make, there's no bleeding body. I need, so it gets into this, the dumbing down of the American populace, the sensationalism, the whole, and maybe I'm not the best communicator. I really am an engineer. So I'll put some of the, some of the onus on me. All right, but this is what I'm claiming to you. I hope it's on the screen. Anyone who wants to see it. The contrary to law, neither the President, Congress, nor agency heads had an objective basis to contest my claims, because MSPB would have to do a special study to give them the objective basis, and MSPB simply will not, won't, even though the law says so. And when I go to Congress with this stuff, it goes round and round. Get the media. I mean, I talk to staffers a lot. They don't disagree with me. They say, get the media to cover it. Then that's how. I go to the media. Get Gap, Peer, Pogo. I go to Gap, Peer, Pogo. Shh. We do such good work for all these whistleblowers. And I liken them to, they're good firemen, but they're also arsonists, in that they allow this government law breaking to go on because it creates the people who need their services. Okay? Now, all right, let's be real. Say there's a dangerous intersection and you're a personal injury attorney. Do you really expect the personal injury attorneys to go lobby the county commission about correcting that dangerous intersection? Okay? All right? Gap, Peer, Pogo. There's a dangerous intersection between ethics and government employment. It creates a lot of bans, a lot of people like me that they can use. And when they do, I'm not going to say they do help, or the individual. They pluck a couple out from the stream. They're poster kids, they're this and that, but they want that dam broken. So there's always a steady stream of people flowing down that they can, pull for. And they actually get this rush. I'm being rescued. We all have that kind of in us. So it's bizarre. They collude with a broken system because it benefits them. And then they'll fix the pieces, so they'll make a diagnosis that's very kind of self-serving. It's not completely wrong, but they never go back to some of the other parts that are broken, because they got to look out for number one too. All right. So, Asia said, in the dark. President, in the dark. Congress, in the dark. America, much diminished and more threatened. Okay? We're missing our, this OSC and this MSPB are kind of like our early radar for problems with the integrity of the federal civil service. It's down, right? We're not getting the feedback loops. We're not steering, you know what I mean? We're driving in the dark. Well, we think when something's wrong, we're not getting, if you go to a doctor with a medical issue, if the doctor, if she does not diagnose it properly, you're probably not going to get the best prescription. But we're not diagnosing what's wrong, we're not going to be prescribing it, properly. What to do? Well, I've been to the Supreme Court twice, and all the steps in between, and no one is telling me I'm wrong, but they always find reason to get the case dismissed, because OSC and MSPB will go to all kinds of lengths to get the case dismissed. And you would think, given their functions in the immune system, you would think, in an ideal world, they would want to say, yeah, let's get a case review. Let's make sure we're doing this right. And we're attorneys. We have to hold MSPB paramount, so if there's any way we can knock this case out, that's what we have to do. That's winning. Is that winning? It's kind of legal ethics, though. All right? So, Obama, as his predecessors, he takes an oath. He's the head of the executive branch. He takes an oath to faithfully execute the laws. All right? Well, laws are complicated. And they can have multiple opinions as to how to interpret them. And what if these laws have not received a court review? And these laws have not. I've tried, they haven't. That's my point. All the cases were dismissed without getting rulings on the merits. So what's the process if you're Obama and there's a dispute or a question as to how a law that impacts more than one agency, which obviously civil service laws impact more than one agency, okay? What's the tool or the process within the executive branch? And the process is, by law, the Attorney General is responsible to advise the President as to how to interpret the law that he's to execute, okay? So that's within the Department of Justice. And within the Department of Justice is something called the Office of Legal Counsel, which essentially is the final referee within the executive branch as to how a law is to be interpreted. So if you go to the library, this law library here at UTK, you won't be able to find all the interpretations that agencies have made of their laws, but you will be able to find Office of Legal Counsel opinions because they take on the force of, it's not a case decision, but it's the position of the administration as to how a law is to be interpreted. So that's some formality to it. You can look it up on LexisNexis. So for several years, I've been trying to get Obama to direct the Office of Legal Counsel to resolve some of these issues, and it's been futile. Because Gap Peer Program, I have to give them credit. They've got this thing wired. Because Obama said, "Well, reach out to Gap Peer Program. And they don't want these things to be examined. They just like things just the way they are. In this sense, just the way they are." Let me tell you another statement. Like you got issues with TVA, right? Did you know that you have a statutory right to go to OSC with those issues, even if they involve classified information? And you can do it confidentially. And if OSC refers it to the head of the NRC for investigation, the NRC has to investigate it and make a public, permanently available report. You didn't know any of that?
No.
You're not alone. But that's the law. That's the law. And even though I'm saying there's about a dozen laws that have not been properly interpreted, I'm willing to stand or fall on these 2 points. Okay? And this is you as an activist, okay? Or me in Department of Energy. We had this break-in at Y12 last year. The Office of Special Counsel has basically said this section of law doesn't exist. It was passed in 1989. It's for 24 years it hasn't existed in the Office of Special Counsel's opinion. And I'm not just making this up. You look at all their annual reports to Congress, it's never mentioned. Okay? Well, call up the Office of Special. They have an 800 number, Don. Call them. Go ahead. Go ahead, please. Make my day. Right? Prove it. All right? And this is where the attorneys at the Office of Special Counsel say, Joe, you're probably right. We're misinterpreting this law, but we don't have the resources. And 2, I'm an attorney, and I can't, because of legal ethics, I can't support the Office of Legal Counsel being tasked to review it. Well, if enough people said, this is fill in the blank stuff, do it, it'll happen. The Office of Legal Counsel, this is what it does all day long, is this kind of stuff, all right? In fact, this 1989 law was passed as a result of 2 Office of Legal Counsel opinions in 1981, one of which involved the NRC, in that an employee of a utility made a disclosure to the Office of Special Counsel about wrongdoing involved in the NRC. And the Office of Special Counsel said, do we have jurisdiction to get a disclosure from a non-federal employee and task the agency head to investigate it? And the answer was, no, you can't force it, but you could certainly, you could give it to the agency head, and the agency head could do something with it, but you can't command them to investigate, okay? And then there was another case where the Office of Special Counsel got an anonymous complaint. It was the same question, could we take this anonymous complaint and task an agency to investigate it? And the answer was, you can give it to the agency, but you can't command them to investigate it, all right? So Office of Special Counsel has always had that prerogative to make these referrals. In 1989, the law was changed to say, and in those cases, if you make such a discretionary referral, then the agency has to do something. It can't just, throw in the garbage can. But since then, it has not happened once, not in 24 years. And you're not even aware of that right. And if you're a TVA, now TVA is a bit different, but if you're an employee of Duke or any commercial commercial as opposed to a TVA plan, you, I'm claiming, have the right to make a disclosure to OSC if it's a violation within NRC's jurisdiction. And then if OSC would refer to NRC, the head of NRC, not the IG, the head of NRC, he or she would have to investigate, report back, and you're kept in the loop. So, and you can be confidential. I mean, this disclosure mechanism gives you rights that no other disclosure mechanism has. Now you might say, well, OSC, because it's discretionary on the part of OSC whether it refers to the NRC, OSC could always say, no thanks, Don. But what's preventing the NRC from going to OSC and saying, please make liberal use of your discretion? Nothing, right? So it's totally at the Office of Special Counsel discretion. And if the NRC were to say, make liberal use of it, someone like you, or any other citizen, or an employee of a commercial plant, they would have another disclosure mechanism that has some properties that no other one has.
But why would they do that? It would just give citizens another avenue for getting into their, for questioning their...
Well, why should, that gets back to this trustworthiness of the Federal Civil Service. If they were a more trustworthy agency, wouldn't they?
Yeah, but the whole design of the NRC at this point is to make it as difficult as possible for citizens to raise any questions, and they deny standing at the drop of a hat, and their rules are so arcane that even attorneys that deal with them all the time get stuff thrown out routinely because of not dotting an I, or whatever it is, it's bizarre, and so.
I'm not. Again, it's not a panacea,
right?
But it's another tool on the table that's being underutilized.
Well, what about TVA employees? I mean, there was a woman this last year at Browns Ferry.
Right.
Joni, I forget her last name. She was an engineer at TVA for 20 years,
right.
Highly trusted and respected, and she was tasked with coming up with the reason why that Browns Ferry plant has a red, which is the worst safety designation the NRC grants, which they don't. It's the only one in the U.S. with that designation. And she came up with her results of her study, and TVA totally changed it, and basically threw her study in the trash can. She came to the NRC at a hearing that I was at Browns Ferry, or in Alabama, near Browns Ferry, and was brave enough to say, here's what TVA did. And the NRC didn't do anything about it, and so she's had to quit, and because of all the pressure she's gotten, and apparently you're familiar with the story, but
so let me tell you what she had.
Mm-hmm.
What I'm claiming, this is point 2. I'm claiming that she had a right to go to the Office of Special Counsel through an avenue available to all of the federal employees, which has more bells and whistles and controls. OSC says she doesn't. I think it's bizarre. The law says it can't be more clear that she does. All right, but she was unaware of that right. Mm-hmm. And had she gone to OSC with our concerns, and if OSC referred it to NRC, because it came from a TVA employee, there'd be a lot more controls as to what NRC would have to do, TVA would have to do to deal with it.
Can she still do that?
Sure. Well, if we establish, because it's current or former employee, we just have to establish that TVA, current or former TVA employees have that statutory right. OSC denies it, even though it's contradicting the law in doing so. And it won't allow for an independent review at Office of Legal Counsel, because it knows it's wrong. Or if MSPB were to do some special studies of TVA and saying, what do you mean you can't go to OSC with a good disclosure? Which it won't do because it knows it's going to find. Okay? I've written to the TVA board. I've got a website with all this correspondence. And the TVA general counsel saying, I have to represent TVA's interests. I'm not going to say you're wrong, but I have to come up with some cockamamie reason as to why we're not going to ask the question. You know, ask the question of the Office of Legal Counsel to give us you would think TVA was really about safety? If there's some possibility of doing a reasonable case to doing it wrong, ask the question, get the answer. Don't need a lawsuit. There's a process within the government to get an answer. Absolutely not. So here we are. You know, we made these systems and they're not working, and it's up to us. You know, I'm doing my bit, but it's kind of I'm going to put it to some extent on people like you. I've had conversations with Mr. Duncan's office, Mr. Alexander's office, Mr. Corker's office, and they're not blowing me off. But they're also, you know, and other offices are basically saying it'd be easier if you had some media attention. Okay? So if you, I don't know if you got my ask, and I'm asking this in a heartfelt manner, but if you will give me your email address where I can contact you later, I'd like to get a joint letter to the publisher of the Knoxville News Sentinel. You know, that Joe Carson not blowing smoke. And if we get some, you know, we get some media attention, we'll get some congressional attention, we'll get some answers. I mean, these are all issues of law. Is there anything that I've said that there's, where my credibility, where I'm talking about, you know, when I said that haven't made a disclosure in 24 years, that's, look it up. Call them. Satisfy yourself. These are all about issues of law. It's not he said, she said. It's like, this is what the law is. What does it mean? And this Office of Legal Counsel is the process by which we're supposed to get answers to that. I've tried the courts. They haven't said I'm wrong. If they had, I wouldn't be going to the Office of Legal Counsel. The courts would have given the answer. So the laws I'm talking about, there's no case law. Go down the hall. Google these sections of law. You'll see there's no case law in 35 years. I'm not going to say there's not case law for any civil service law, but these specific things, no. All right, we're getting close to our time. Any other questions? Yes.
So what were the names of the Supreme Court cases?
Just, well, when I went to the Supreme Court, I did, but you know the Supreme Court, you don't have appeal as a matter of right. You have to do the petition for, what's it called? Certiorari. Little tidbits about the Supreme Court. How many appeals go to the Supreme Court every year?
A lot.
10,000. How many come from inmates? About 6,000. Okay? Of those 10,000 appeals to the Supreme Court, how many just don't get, petition for certiorari is denied in a year? How many, of these 10,000 cases, how many a year the Supreme Court sees, how many does the Supreme Court do something other than say, just deny it at the initial step? About 150. And of those 150, it'll go the whole bells and whistles about half the time, about 75 cases with the oral briefs, okay? And about 75 times it'll dispose of it, not without just denying the petition for cert, but it'll dispose of it. It might give some instructions and then remand it back to the appeals court for further adjudication. So that's your chances. Anyway, so that's so I say, why do you want to be a Supreme Court judge? You're going to get all these, stamped, denied, and all these, the literal jailhouse lawyers making their appeal up to the Supreme Court for this, that, or the other. So again, did you get? I had my family here. Did you get this? Okay. If I have my business card with me, if you'd like to chat later, but I'm really making this a heartfelt appeal. If we get 10, 15, 20 people to write to McElroy at the News Sentinel, he may say, all right, we're going to devote the journalistic resources to run this down. And what's the First Amendment for, if not to, give the paper the ability and I think responsibility to go after allegations of government law breaking? So how much do we trust the papers now? We don't want to read about the Kardashians or the celebrity. We want to actually hear if someone's making a valid, well-evidenced claims of government law breaking. The press ought to be on top of that. Sorry. That's why I'm here talking to you. So, yes.
So do you have a draft letter of what you would want people to write, like on your website, to make it easier?
I will get one. Or if you contact me, we can do it, see if we can do a joint letter. Or have a model for us, an individual letter or an email. Anything else about my 20-year civics lesson? I feel like the proctologist of the Federal Civil Service, just every little...
So do you have a sign-in sheet for your email for us to give us your
Yes, okay.
email?
Thank you. I'll put this up on the back table. You want to give me your... I'll also put a stack of my business cards.